Welcome to the masterclass on India's Digital Personal Data Protection Act. Let's introduce the key players. The data principal is the user. The data fiduciary is the company that determines the purpose and means of data collection. The data processor is the third-party vendor handling the data. And the Data Protection Board is the government regulator enforcing the law. It all begins with notice and consent. Before asking for any personal data, the fiduciary must provide a clear, itemized notice. The principal then reviews the notice and grants explicit, unambiguous consent. Only then is the data securely encrypted and stored by the fiduciary. Now the data enters the processing phase. Under the law, data is bound by strict purpose limitation. Sending an authorized task to the processor for the exact consented purpose is perfectly fine. But if the fiduciary attempts to perform unauthorized analytics outside of that original scope, the action is strictly blocked by DPDP rules. The DPDP Act also grants citizens powerful rights, such as the right to erasure. When the principal withdraws consent and requests deletion, the fiduciary must comply. Crucially, they must erase the data locally and immediately mandate their data processor to delete all copies. A final confirmation of erasure is then sent back to the user. Finally, let's look at data breaches. If a threat actor exploits a vulnerability and breaches the fiduciary's systems, hiding it is strictly illegal. Under the law, the fiduciary must immediately dispatch mandatory breach notifications to both the Data Protection Board and the affected principal. The board will then investigate the incident and can levy massive financial penalties, up to 250 crore rupees, for failing to protect personal data.